A very good morning and welcome all of you to the daily news analysis for 16th of February 2025 with me Jatin Verma. So in today's news analysis we are going to first of all talk about a case study on stampede on New Delhi railway station. This is the second stampede happening in the light of the Mahakumbh that is going on in Prayagraj. Why this stampede happened? Why was it avoidable? Yes. What are the precautions that you as a DM, that you as an IAS officer or as an IPS officer or as an Indian Railway Traffic Service officer could have avoided? Right. So we are going to talk about these things, even though we are managing world's biggest congregation, but that cannot be an excuse for these frequent stampedes happening. In November 2015, the same railway station, the same kind of announcement and the stampede. This year again, the stampede is happening. Are the lessons not learned properly despite so many deaths, so much of loss of life? We are going to see this. Crowd surge and confusion over trains led to stampede. So first thing first, point number one, number of usual tickets, the platform tickets that are sold between 8 and 9 p.m. or 7 and 8 p.m. is 7,000. Number of tickets sold between this time slot, the peak time slot on the day of the tragedy was 2,600 higher than the usual number. That means instead of 7,000, 9,600 platform tickets were sold. Was this guideline not there in the SOP, in the standard operating procedure, that if the number of tickets is jumping by more than, let's say 10% than the usual number, then the number of tickets, the crowd management should have kicked in. Okay, we have lessons from Vaishno Devi Shrine also, the ticket system is there. If in case the number of crowd, number of people at the shrine is higher, then we cut down on the number of tickets. Issue of the tickets is cut down, keeping in mind the strategic location, the vulnerability to the terrorism in Vaishno Devi. Same kind of stampede happened here also. The area where the trains are, with the platform area is very limited. How can you allow so many people? Second point here, that if the train's announcement happens, any delay or any change of platform, there needs to be a gap of at least 25 to 30 minutes. This is the takeaway from this tragedy, that at least 15 minutes time it should be given. Ideally, the platforms should not be changed abruptly, leading to the crowd panic among the crowd. If the crowd panics, then what happens is, out of the rush to not to miss the train, they start panicking and the stampede happens. So if there is any change in the platform at the last minute, that should be given at least 15 minutes of breather. The crowd should be the people who are going to onboard the train. They should be given at least 15 minutes of time period. These kind of small lessons you can learn. Now I give you a question in the light of this. What are the precautions that you would have taken in the light of the trains which are destined towards a festive location, trains that are destined towards a pilgrimage? What lessons would you have taken to avoid these kind of stampedes at the railway station? Okay, I've given you few points here from the mere reading of the newspaper, that if there is a surge in the platform ticket sale by more than 10%, and what is the crowd holding capacity of the platform? If the platform cannot hold so much of crowd, how can you go on selling the tickets? What was the police doing? Could they not envisage? Where was the station master? Could he not envisage that the abrupt announcement of the change of the platform or delay in the train would lead to crowd panicking? Right? If trains come abruptly, even as sometimes the station masters they are caught unawares. They are not aware of it. If the platform holding capacity is this much, why was so much of crowd allowed? Number one. Number two, delay in trains, if any, or change of platforms at the last minute should be given at least 15 minutes. If there is any abrupt change of platform, the passengers should be given extra 15 to 30 minutes to board the train. Otherwise, these kind of tragedies have happened in 2010, 2012, 2015. Platforms number of death toll changes, but the tragedy, the same SOP, the recipe of the tragedy remains more or less the same. So this was completely avoidable, but it is India. Right? Now, moving further, This is how you have to take it. Okay, a 2-member committee has been appointed. Those things are of no relevance for our exam, UPSC Civil Services exam. So today we are starting off with the disaster management. How this crowd management, as an IPS officer, how would you do that? As an IAS officer, how would you do that? As somebody from railway traffic service, even though railway traffic services job is something else, but yes, this should be a part of their training when it comes to abrupt change of tracks, abrupt change of platforms, then delay or sudden arrival of the train, right? So those things need to be avoided. Now moving further, the other news articles that are there, Chhattisgarh High Court extends marital rape exception. Today we are going to talk about section 375 and section 377. Even though the numbers of sections have changed in the new Bharatiya Nagrik Suraksha Sanhita, but the recipe, the basic, underlying context remains the same. So we are going to talk about this also. Despite 24-week limit, why Bombay High Court allowed termination of a 25-week pregnancy at a private hospital? Can the termination of pregnancy under Medical Termination of Pregnancy Act, can it be allowed at the private hospital? Rule 5 talks about it. Okay, section 3, 4 and 5 are going to be discussed in today's news analysis with regard to Medical Termination of Pregnancy Amendment Act that was passed in 2021. Okay, earlier act is 1971, but amendment was brought about to give the relaxation, to increase the period of medical termination to 24 weeks. In the light of increasing lifestyle diseases, genital disorders, even as the modern medicine is advancing, the medicinal technologies, they are advancing, but still the kind of abnormalities that are observed in the fetus these days, they are not observed in the past. And thanks to the advancement, we are able to detect such fetal abnormalities at an early stage or at a later stage as well. So that is why Medical Termination of Pregnancy Act was amended in 2021 to incorporate these advancements in technologies to detect the fetal abnormalities. So we are going to discuss these. Bombay High Court has relaxed it. As I was explaining you in the polity class, this relaxation basically, reading into the Bombay High Court read into the law the provision for incorporating the private hospitals also. Okay, so we will deal with this now. Other news article, West Bengal and governor. Earlier we saw Tamil Nadu and governor, now West Bengal and governor. The controversy here is around Article 176. In the previous days we have been covering Article 174. Now it is Article 176. Article 176 talks about the opening address of the governor. Okay, every year during the budget session, the opening session of the first year, the governor addresses the house, the legislative assembly, and this address is written by the ruling political party, that is the government. Okay, it is on the aid and advice of the Council of Ministers. There were certain last minute changes made in the budget, in the opening address of the governor, that is being criticized in the West Bengal Legislative Assembly. Why the governor changed the context of the speech? Even though he was talking about the policy of the West Bengal government, but he deleted certain references to RJ Kar hospital tragedy, the rape that had happened. Okay, the sad incident of rape was omitted. So he was asked why did he delete it. He said that the cabinet did not want it to be mentioned, so I deleted that. So such tragedies are something that we take a lesson from, that the ruling political party or the government takes a lesson from, why these things were deleted. So this is the context, but we are going to learn about our Article 176. This is how you cover polity on a daily basis. This is how you cover economy on a daily basis. Today we are going to talk about sovereign green bonds as well. Okay, so these are the news articles. High level committee formed to probe New Delhi railway station stampede. What are the sovereign green bonds? This is going to cater to your economy. This is polity despite 24-week limit. This is GS mains paper 2. Then how Chhattisgarh High Court extending marital rape. GS mains paper 1 and 2 also to a great extent. Okay, social issues also. how the definition of this marital rape is evolving, what case is going on in the Supreme Court, what is the jurisprudence evolving on this matter. Then how speeds reflecting the reflection of the government views. This is the West Bengal thing we just talked about. Why are BRICS and New Development Bank important? Okay, so this is for international relations, again GS mains paper 2. So this is for your GS mains paper 3, disaster management. This is how we are going to categorize the news articles on a daily basis, so that you get to know how you categorize these news articles, what is the applicability for your paper wise preparation, okay, of these news articles. Now, crowd surge and confusion over the trains led to stampede. As I said, take a question, a case study. If you were the IAS officer, if you were the DM in charge of the disaster management or stampede control or stampede management, stampede avoidance, what would you have done? Okay, what SOP points would you have kept in mind, and how you would have trained the staff, be it the platform ticket sellers, be it the railway police force, the sepoys that were there, the constables that were there, and how you would have trained the porters, the coolies that are there. They are respectable, they are, but yet, I mean, they are an important link in the overall preparation of stampede avoidance or stampede management. If at all stampede happens, those porters, those red shirt guys can rescue a number of people. Okay, so they rescued 50 to 100 people in this stampede, even as they were themselves putting their life at risk. So how the cutting edge people could be managed, how would you take such people, such ignored or petty people into your scheme of things to avoid such kind of disasters? So this is the case management kind of a question today. You can answer in the comment box of this YouTube itself, okay, the stream itself, in the comment section, so that just 5 to 6 points on the basis of reading of this mere news article. This is how you prepare. Since 2 stampedes have happened, the question is highly likely in the coming mains. Okay, so 2025 mains, you can expect a question on stampede management as a part of the disaster management preparation of your UPSC exam. Now, moving further, coming to this part, sovereign green bonds, why they are not picking up in India? What is the reason? What is green bonds in the first place? Green bonds are meant to finance the green projects, solar panels, wind energy, etc. Okay. Now, the point is, they do not carry as much of return on investment as the conventional bonds. Having said that, the bond market in India, in which I as a lender, I want to invest 10,000 rupees, okay, in the bond. How would I do that? The market is not well developed for bonds. Even though we are seeing a lot of activity by retail investors in the share market, but that kind of an activity is not witnessed in the bonds market. What is a bond? It is a kind of loan that you are lending to the company. Okay, let's say you are lending this bond to the government, sovereign green bond, SGB, and government is investing it into the private sector or public sector green projects, energy efficiency, to minimize the carbon footprint, those type of projects. Now, the problem with these green bonds in India is, if I am as an investor or you as an investor want to invest your, let's say, 1 lakh rupees, you get a rate of interest which is very low, okay, as compared to the other bonds, other debenture instruments. If I lend it to Tata Steel, I will get 11 to 12% rate of interest. If I lend it to bank, I get 7 to 8% rate on FD, right? But the rate of interest on these green bonds is lesser as compared to the other debt instruments. Debt, you understand? This is a kind of debt instrument in the money market instruments, in the capital market instruments that we talk about in the Indian economy. So retail investors are not enthused. They are not that what I at the end of the day, as an investor, what do you need? As a UPSC aspirant, what do you need? You need selection. Similarly, as an investor, what an investor needs is a decent rate of interest which cushions him against the effect of inflation. That characteristic is lacking in this bond, okay, green bonds, so as they call it. Now, India introduced these bonds in 2022, but they haven't been able to gain that traction. And the interest or the return that we get on it is called green premium or greenium. So, note it down. If it is fairly visible, then it is fine. Green premium or greenium. It determines the cost advantage of the green bonds. Okay. Are we getting some? I mean, if the project is being financed by the green bonds, it is cost advantageous for the project. But as an investor, is it advantageous for me to invest in it? No. If the investors are not happy, green bonds or any investment instrument for that matter may not be as lucrative, as attractive. So that is why government is not able to borrow enough money to finance the green projects in India from these instruments which are known as green bonds. Okay, and the effect of this is visible on the various green projects in India. Even though government had projected to, had planned to invest 10,000 crore rupees, but now the target has been slashed to 1500 crore rupees, because the money that the government had thought will be generated from the green bonds issue, like we issue shares, Zomato issues shares to the people. Okay, so government had thought that money would be able to be collected from that, but because of poor interest, the impact is visible. The government's inability to raise inadequate proceeds from the sovereign green bonds, as they are written in the short form in this manner. Sometimes you come across these type of acronyms in the prelims. What do you understand by this? What is the meaning of greenium? This is how the questions are asked in the UPSC prelims, guys. Okay. Okay, so this is there. Now, quickly note down these terms. Many of you keep on asking, sir, how to make notes out of the newspaper. This is how you make notes out of the newspaper. Okay, SRGBs, what do they mean? Now, allocation of a scheme promoting grid scale solar projects. Grid scale means very small or very big. Okay, grid, depending upon the size of the grid. The investment has been slashed from rupees 10,000 crore rupees to 1500 crore rupees only, 1300 crore rupees rather. Now, other things, sovereign green bonds of India, Government of India's framework in 2022 defines green projects as those. So these bonds, the money that will be collected through the medium of these bonds will be invested in the green projects. That is why the definition of green projects as per the Government of India is important, because money will be invested only in those projects which are labeled as, which are approved as green projects. Okay, so that is why the framework was readied in 2022. It says that green projects are those that encourage energy efficiency in resource utilization, reduce carbon emissions, promote climate resilience, and improve natural ecosystems. Is this definition important for prelims? No. Is this important for mains? If you can memorize certain aspects of it. Okay, so this is how we can categorize. You don't have to read too much detail for your prelims examination. Okay, very specific minute details are not important. Only a broad idea is important. Now, since 2022-2023, India has been issuing these bonds, and it has issued these bonds 8 times, and the money collected is 53,000 crore rupees. Each year, the government uses roughly 50% of the proceeds from sovereign green bonds to fund projects of energy efficiency. Energy efficient 3-phase electric locomotives through Ministry of Railways. Okay, so electric locomotives, by replacing the diesel locomotives, the diesel engines, they are being replaced to reduce the carbon footprint of Indian railways. Okay, now why are the investors not excited? Low greeniums. As we said that the premium paid on these green bonds is called greeniums or green premium. So green premium, the investors return is not as expected. Okay, so 2-3 basis points, 2 to 3% interest is given on them. Now, how to enthuse the investors' interest in it? We understood the problem. What is the solution to it? Either you can give tax rebates, tax incentives, that if somebody invests rupees 10,000 rupees, it will be considered as 30,000 rupees for the purpose of income tax deduction. That means if, let's say, a person's income is 10 lakh rupees and he is supposed to pay, okay, a person's income is 25 lakh rupees and he is going to pay tax on 25 lakh rupees. if he invests rupees 1 lakh rupees in the green bonds, he will be able to deduct 3 lakh rupees out of his income and then pay the tax on remaining 22L. That is how the government can make investors feel investing in these type of funds, otherwise investing in these type of bonds, otherwise these bonds will not be able to take up and government will not get the money for its green projects. Okay, so tax incentive can be one way of in evincing or enthusing the investors to invest in these type of schemes. Okay, so this is there. India lacks a strong ecosystem of social impact funding. So these type of green bonds, okay, farmers bonds, etc. So they are called, they come in the rubric of broad category social impact bonds. Okay, so we as Indians, we don't feel for investing in a particular thing for the sake of cause, for the sake of cancer eradication, for the sake of solar energy, for the sake of Mother Earth. Okay, so social impact bonds as a category includes sovereign green bonds as well. Across the world, the governments have come up with these type of impact bonds, social impact bonds, bonds for eradication of slums. But in India, we don't feel for that, right? Because inflation is very high, investment instruments are not as great, and majority of us are middle class. So middle class will first think about itself and then about the rest of the impacts. Got it? So this is there. Now, sovereign they take considerable time to prepare the post issuance allocation. Now the government also is lackadaisical here. Government is also at fault. If the investor is ready to bear lower rate of interest, okay, he is ready to swallow this. Still, the government takes a lot of time in the post issuance allocation. Like UPSC, you apply for the form, okay, you get the roll number allotted in next 1 month, right? But government, after me paying the 10,000 rupees for purchase of sovereign green bonds, the allocation happens pretty late and the interest payments are also delayed. So these kind of issues also wean away the investors, also turn the investors away from these type of green bonds, even if they want to invest in it. Post issuance allocation is also very tardy, very slow. Got it? Issuance should not take more than a week, as is the norm by SEBI nowadays for the IPO. If you apply for the shares, it takes a minimum, maximum 7 to 14 days for the shares to be credited to your demat account. Then why not these green bonds? So this is there. You understood overall what are the problems with the sovereign green bonds. This was an economy topic, so we dealt with it today. Now moving to the other topics, we have covered this topic, sovereign green bonds. First topic that we covered is how would you as the officer in charge manage the stampede. Now this is the UPSC PYQ or MCQ, practice MCQ on these sovereign green bonds. Have a look at it quickly before we proceed on to the next article. Moving further. Despite 24-week limit, why Bombay High Court allowed termination of 25-week pregnancy? Let me give you a context of it. See, Medical Termination of Pregnancy Act 1971 versus Amended Act, same MTP, Amended Act 2021. Okay. This applies to only married couple, married women only. Okay, but this applies to even the live-in partners, the victims of sexual assault. If anybody, because of the offense of rape, because of the crime of rape meted out at her, gets pregnant, then this covers even non-married women also. Okay. Here, ordinary period when the abortion was allowed was 12 weeks. Okay, I'm writing in short form. This is how you are supposed to make your notes in quick language, very crisp language, crisp sentences or keywords only. Now, here maximum period ordinarily allowed is 20 weeks. Now, you should ask me, sir, why? Why there is an increase? Okay, so increase in the light of the medical advancement. in the technologies to detect fetal abnormalities. Okay, if the fetal abnormalities could be detected thanks to the advancement in the medical technologies, why not let the women decide their freedom of choice, through their freedom of choice, whether they want to keep an abnormal fetus or not? Okay, there are grounds on the basis of which the right of women to abort the baby, abort the fetus, could be decided. Number one, if the continuance of the pregnancy could cause severe physical or mental injury. There are points, we are going to talk about these points. Okay, so first major difference is 12 weeks, 20 weeks. Now, going ahead, what happened here, if the pregnancy is beyond 20 weeks and up to 24 weeks, a medical board's approval is required. Okay, a medical board is to be constituted in every district by the state government. Earlier in this act, what used to happen is every time women would go to court and court would give the permission. So court listing of matters, the procedural delay would take another 1 to 2 weeks, even if the court is sitting on Sundays for these type of matters, but the time will be going in vain. Wastage of time was there. So that is why the government thought it right, in the light of frequent such cases of request for fetal abortion landing up in the court, Bombay High Court, Chennai, Madras High Court, okay, then finally coming to the Supreme High Court. It would consume 2 to 3 weeks when the overall pregnancy is of 35, 36 weeks. So why to waste the precious time was realized by the Parliament of India, and finally they amended this. UPSC had asked a question in mains also. Now here what is happening? In this case, after 24 weeks, as I said, medical board is of expert doctors, which is in a way standing board. Okay, it is not to be constituted every time such a case comes, because that will take another 2-3 days to constitute the board. State government will notify, district collector will notify. That will lead to another wastage of time. So that is why already the boards have to be set up in every district. They will decide whether the fetus could be aborted after 24 weeks. Memorize this. Okay, now criteria, medical practitioners also have to examine if what is the criteria to allow the abortion after 24 weeks. Risk the life of the pregnant women. First of all, the risk to the life should be given the prime importance. Then the danger of physical and mental illness. Okay, somebody mental trauma because of the fetal abnormalities the women is unable to bear, or they hail from a poor family, they may not be able to go for multiple surgeries. Second point, if there is a substantial risk that if the child were born, it would suffer from any serious physical or mental abnormality. Okay, so here we are trying to balance the right of women over their body and the right of fetus. Okay, right of fetus. Why the 12 weeks limit was kept earlier? Because it was believed that right of women here, okay, and the right of fetus. Why? Under Article 21, earlier it was believed that after 12 weeks the fetus is viable. Viable means, that means he or she would be able to grow on his own, and the fetus develops the heartbeat. So that means there is life in it. So on the great land of India, otherwise also in other countries also, Article 21 bestows right to life on a fetus in the womb of the mother. So mother loses partial control on her fetus, on her bodily integrity, once the fetus has got viability. That was the logic of keeping 12 weeks limit. Okay, Article 21, 12 weeks limit, right to life of a fetus versus right to life of a woman. Right to, whether to conceive a baby or not, those rights are given to the women. Yes, they can decide, but commensurately, right of the fetus would also be asserted, even if the fetus cannot hire a lawyer. So that is the beauty of Article 21 in our country. Now, Section 4 of the MTP Act says a pregnancy can be terminated at a hospital approved by the government, or any other hospital which is not government hospital. If the government approves it, then it is allowed. And the other hospital is private hospital with the approval. Okay. But the problem is, in case of private hospitals, the period is 12 to 20 weeks only. In the case of government hospital, period is even up to 24 weeks. Okay, got it? Here 12 to 20 weeks. Beyond 20 weeks, you have to go to the High Court, you have to go to the judiciary. Okay, so that is the problem. Now, Bombay High Court has heard this plea, and Bombay High Court has said that why private hospitals should not be included in the Form A that is to be filled up under Rule 5. Rule 5 talks about two categories, 12 to 20 weeks. Why beyond 20 weeks is to be approved? Why beyond 20 weeks is not given in the Form A? Three options should be given: pregnancies of 12 weeks, pregnancies of beyond 20 weeks, okay, and up to 24 weeks. But beyond 20 weeks, beyond 24 weeks, there is no option given. So these are the only two options. Now Bombay High Court has said that there should be a third option, that if the private hospital, if the woman wants to abort her baby at the hospital of her choice, the private hospital which is near to her, which is within her city limits, or which is within her traveling limits, considering the health of women, considering the surgery that needs to be done, or the cleansing that needs to be done in case of abortion, why she should not be allowed to choose the hospital of her own choice? Even though the private hospital is allowed otherwise, why not allow her the private hospital's choice, the hospital of her choice, even beyond 24 weeks? Okay, so that is the issue here. Now, here you see Form A has to be submitted for approval for termination of pregnancy, and it includes two categories only: termination of pregnancy up to 12 weeks and pregnancy up to 24 weeks. Right? Beyond 24 weeks, there is no option. So what was the issue raised before the High Court? The petitioner submitted that there was an ambiguity in the rules, as there was no third category provided in Form A for the termination of pregnancy beyond 24 weeks. As a result, the hospital of the petitioner's choice did not have a certificate to terminate the petitioner's pregnancy. So beyond 24 weeks needs to be incorporated in this thing. Okay, so up between 20 to 24 weeks it is allowed. Beyond 24 weeks, every time they will have to go to the court, or they will have to take recourse to some legal remedy. So the problem is, why? Let me tell you, why did we not incorporate the private hospitals beyond 24 weeks? Because some malpractices happen. Private hospitals are bribed sometimes to abort the baby. Beyond 24 weeks, if they abort the baby, in the government hospital, the staff is permanent. They are having a threat, they are having a fear of losing their job, government hospital doctors. Okay, but in private hospitals, if we allow the pregnancy to be terminated beyond 24 weeks, if we give the third option, then private hospitals might resort to a scenario where they will start aborting the baby by taking 1 lakh rupees extra, 2 lakh rupees extra, okay, which might lead to circumvention of the act. The intent of the act is to respect the right of the fetus to take birth, if everything goes normal, if everything is going on normally. So why that fetus should be aborted? Then you also understand the fear of the sex selection, etc. Okay, those malpractices under the rubric of fetal abnormality might also happen. Under the guise of fetal abnormality, female feticide might happen. So that is why private sector hospitals are excluded in Form 4A. They are given only two categories. And logically also, since the upper limit for abortion is 24 weeks, beyond 24 weeks, the abortion needs to be approved by the medical board. So if it is an exception, why that exception be given as a luxury to the private hospitals? It might lead to misuse of the legal provision. So that's why. Okay. Now, it was argued that pregnancy beyond 24 weeks can also be terminated if the necessary facilities are available. It's not about the facilities, it's about due diligence, it's about checks on the malpractices. Okay, due diligence by the government. So that is why private hospitals they are automatically not allowed to abort a fetus above 24 weeks of pregnancy. That's it. Now, moving further, Chhattisgarh High Court, another interesting matter. Chhattisgarh High Court, okay, this extending marital rape exemption to section 377 removes all recourse for women. What do you understand from the headline? Headline says section 375 IPC has got an exception to rape. Section 375 deals with the rape. Okay, let me explain this. Okay, not covered. That means a women complainant, if she says that she's been raped in the marriage without her consent, the husband is, insisting upon, or husband has indulged in the act of forceful sex. So that amounts to rape. Anything without a woman's consent is rape, right? So section 375 says no, because if an adult woman of the age of 18, okay, so these are conjugal rights matter basically. Here both of them have married, so that means both of them have surrendered their autonomy. Okay, so since they are married, so they have surrendered their autonomy, versus women's right to bodily integrity. If the women says no, how could the husband insist upon having sex? One matter. Then what is the legal recourse available to women? So in the absence of any protection under section 375, since rape is not covered, women would take recourse to section 377. What does section 377 say? Section 377 says any sex, any intercourse, any such physical relation against the order of nature. A man having sex with a man. We are talking openly about these matters just for the educational purposes, so that you understand the essence of it. Okay. Section 377 says any intercourse, any such relationship against the order of nature. A female having sex with, or intercourse, or any such relationship with female. Homosexuals. Okay. So this women would, now one thing is homosexuality, section 377 covered, but de facto women started taking recourse to this section, that any sex against any physical relationship against the consent of women would also be considered to be against the order of nature. Got it? So they would go to the courts, at least they would lodge a complaint, because here the option of complaining is not available to women at all, because marital rape is an exception. Even though the case is still pending in the court, guys, okay, marital rape is still not an offense. So where would the women go? Women would go here. Women would take recourse to section 377, which gives them an option to at least file a complaint against the husband who is insisting upon, or who has indulged in the act of forcible sex. That forcible sex would be construed to be against the order of nature. What is the nature? When two consent, it was amplified in this manner. This section 377 was extrapolated in a manner that any sex which is against the will, against the consent of both the partners, will be considered to be against the order of the nature. Okay. Otherwise, it included homosexuality. Okay. Against binary. Any sex out of the binary, be it bestiality. What is bestiality? Bestiality means the act of having sex with animals. Okay, there are some people who are attracted to animals, etc. So bestiality means that act. Okay, so these type of blatant cases of, extreme cases of homosexuality, not extreme, I would not say homosexuality as extreme, but animals, sex with animals, etc., that was covered here. Got it? But women started resorting to this thing, which attracts up, this sentence of 10 years of imprisonment. If the woman alleges that husband has indulged in the act of raping her or forcible sex, this was covered under de facto, this was covered under section 377. Now, what has the Chhattisgarh High Court said? You understood the context here. Chhattisgarh High Court is now saying that since section 377 has been in 2018 read down by the Supreme Court. Read down means homosexuality is no longer a crime. Okay, since homosexuality, the parent crime under this category, is no longer a crime, the secondary crime which was covered under this is also not a crime. That means in the absence of section 377 now, women have no recourse, no legal recourse to their problem of, or to their grouse of, or to their complaint of forcible sex within the rubric of marriage. Okay, we are not going to talk about this conjugal issue right now, whether marital rape should be abolished or not. That is a story for some other day, whenever Supreme Court comes out with something, whenever some editorial gets there. Okay, some editorial comes in the newspaper. You understood this matter? Now Supreme Court, this was not there, this was there to some extent, ambiguity was there, but now that ambiguity has been so interpreted by the High Court of Chhattisgarh that women now do not have any option to get their husband punished by the law under section 377 also. Got this? So this is the problem. Now, section 377, and in 2013, Chhattisgarh High Court judgment also talks about the 2013 Justice J.S. Verma Committee recommendations and the resultant amendment to the criminal law, section 375, in which marital rape exception has been still upheld. Okay, the amended act also incorporates marital rape exception. That means marital rape would not be considered as an offense. So it said that since 2013, amendment to section 375 also retains it, and in 2018, Supreme Court has read down the law. That means women have no recourse to any such protection under the marriage, under the section 377 or 375. So this was the aspersion, this was the doubt that was raised by legal commentators when Bharatiya Nyaya Suraksha Sanhita was in the draft stage, that Bharatiya Nyaya Suraksha Sanhita does not incorporate section 377 at all. Non-incorporation of section 377 at all means that since women were taking the recourse to protection under section 377, that protection does not have any statutory mention now, any mention in the act now, the new Bharatiya Nyaya Suraksha Sanhita now. So that means women theoretically do not have any protection. That is why when the Bharatiya Nyaya Suraksha Sanhita was being drafted, legal commentators, the legal experts, they had said that we should at least incorporate section 377 and we should keep homosexuality as decriminalized. Don't criminalize it, but at least retain it for the purpose of, for the sake of women getting some protection from marital rape type of instances within their marriage. Got my point? So this is the understanding part of it. Now you can read it through your PPT. The PDF will be shared right after the daily news analysis on the Telegram channel. It will be shared right after. Okay. Now moving to the other news article, I've incorporated the gist of it, which is relevant. The summary has been so edited that you don't have to read the entire editorial. Okay. Now, let me tell you about the case, what had happened. In this case, a woman had alleged that she has been raped against her will. Okay, and she subsequently died. The trial court had punished her husband for culpable homicide not amounting to murder, section 304 IPC. Homicide means killing the human being. Culpable intention, okay, homicide not amounting to murder. These charges were there against the husband, and trial court had given him the punishment. When the case went to High Court, from the trial court, High Court absolved the husband of section 377 and section 375 both. Why? Section 375 does not have any such offense called marital rape because it is an exception to rape category. Section 377, the High Court said it does not exist, neither in Bharatiya Nyaya Sanhita. Secondly, the Supreme Court gave a judgment in 2018 that section 377 is decriminalized. Okay, so that is the crux of it. Now moving further, House speech reflection of the government views, not Raj Bhavan's. Okay, so C.V. Ananda Bose, the West Bengal governor, now says that he is defending himself as to why in the governor's speech, in the governor's opening address under Article 176 of the Constitution, governor is formally required to address the state legislative assemblies opening session. What do we mean by this address? Here stands the governor. He is reading out the message written by the state government to all the MLAs. He is basically outlining the policy document of the government for the coming year. Okay, but before the budget is laid down, he reads out the contours of the policy of the government for the coming year. This is a formal process every year under Article 176. Now, when the governor reads out this statement is actually written by Council of Ministers, which aids and advises the governor. Okay, Council of Ministers writes this policy document and governor is made to read this out. Governor says that why you are asking him why there is no mention of RJ car rape the incident that happened, the tragic incident that shook the conscience of the whole of the nation, why it doesn't find any mention in your speech. Governor is saying, don't blame me. This is the government's policy. This is the government's policy document. The speech came to me via email and I went through it. I had raised certain objections which they disagreed with, which the Council of Ministers did not accept. So I had to proceed according to what the Council of Ministers says to me. Okay. So governor's address is not the governor's policy statement, but that of the state government. So you should know that the opening address as read out by the governor, okay, is not the governor's own own viewpoint. It is as per the aid and advice of Council of Ministers. Okay, under which article? You have to tell me the article. Which article is it? Article here I am telling you 176 article is there every year. And this happens on two occasions. Okay, one, the opening address after every general election. For example, when the West Bengal Legislative Assembly election will happen, that year governor will outline the policy of the newly elected government for the complete 5 years. One. Second, every year across these 5 years, throughout these 5 years, before the budget announcement, before the budget speech by the finance minister, every year the new session opens in January. First session happens in January. So every year in January, governor will read out the policy statement for that year from January to December. So this is what is written in Article 176. The other day we had seen Article 174. In what context? In the context of Tamil Nadu governor, right? In the context of your Manipur also. So these articles, the federalism, the role of the governor, the controversies surrounding the office of the governor, we will be covering this throughout the year. As I said, 1000 to 1500 topics will be covered through this news analysis. And the way I am presenting it, it is in the integrated manner that you get to cover the angle for prelims. We are highlighting the prelims oriented facts also, and we are highlighting the mains oriented analysis also. So be with me. We'll eventually cover all this. If you ask me, sir, do we need to join any course, etc. for this purpose? I would say no as of now. Okay. Static portion is being incorporated in your news analysis in this manner that you get hold of the static. Some part you can read from books like M. Lakshmikant, Nitin Singhania, etc. for your static portion. 70% of the things here are current affairs oriented, 30% of the facts that I tell you so that you get to understand the current affairs well. Every day, GS mains paper 1, 2, 3, 4, some articles are appearing. Okay, case studies sometimes, etc., etc., as and when it appears in the newspaper. Now, this is the UPSC MCQ. Why are BRICS and New Development Bank important? Why this news has appeared? Quickly, I'll tell you. This news has appeared in the light of Donald Trump threatening the BRICS countries of levying with 100% tariff. If any goods come from the BRICS countries, Brazil, Russia, India, China, South Africa, and now the expanded version, UAE, Egypt, etc. have been included. Okay. So if any goods come from the BRICS countries, those goods would be charged with 100% customs duty in the US. Why so? Because BRICS is a grouping which is threatening America, which is threatening USA with an alternate to dollar. One of the agenda, one of the recurring theme in the BRICS summit joint statement, whenever the BRICS countries they meet, they issue a joint statement. That is the formal process with every such grouping, every such country, India, France, joint statement. So whenever they release the joint statement, the recurring theme in the joint statement is de-dollarization. They want to find out an alternate to dollar because of the vagaries of dollar. Okay, I mean the fluctuations in the dollar value lead to the fluctuations in Indian rupee. If Donald Trump has won, we are going to face the brunt. That is one of the reasons. Another reason is, since US economy is not as great as it used to be when dollar was the the dollar was representing the wherewithal of US, or dollar was representing the heft of US in the economic, in the financial world. Now that is not the case. So that is why should these BRICS countries, or why should the southern part of the world, global south, why should they bet their, or they peg their economies to an economy's currency, US dollar, which is already fledgling, which is already losing its heft or power. So that is why BRICS countries, being one of the leading pillars, I would say, of the changing global shift from global south, this is global north, to global south, to countries on the southern side of the equator. So BRICS was representing this transition, and the term BRICS was coined by, it was BRIC that was coined by Goldman Sachs, a financial merchant bank. Okay, so institution. So they said that these countries represent a rare scenario where their GDP economies, etc., they are going to grow for next 30-50 years, and they have same level of development. Barring Russia, all these countries have same level of population growth, same economic development growth, and a big middle class, which is going to help them have domestic consumption led growth model. Even if USA is declining, European Union is declining, these countries would be resilient enough and will give growth for the next 30 to 50 years. So it was on the basis of this research by Goldman Sachs, the term BRICS, which was just coined as a term, got converted into a BRICS grouping, which is now expanding to the extent that now Iran, UAE, Ethiopia, these countries have been incorporated in 2024 in BRICS. In 2025, Indonesia has also joined as the latest member to BRICS grouping. So these things are happening. Okay. Egypt also, barring Saudi Arabia, all these 4 countries have recently joined BRICS. So if the question comes, you have to be very thorough with it. You can't afford to have factual mistakes. Now, Donald Trump, ever since he has come to throne, ever since he has come to become the president again, he's been talking about the protectionist agenda. Sometimes he's breaking away from World Bank, sometimes he's talking about WHO, sometimes Canada, Mexico, all these countries. Now, BRICS countries, since they present a kind of pole, integrated pole, representing the global economic shift from the Western world, from the G7 grouping of countries towards the global south. It is something that is non-palatable, non-acceptable, non-digestible to the new US president, who has been talking just about the protectionist agenda of the US. Okay, so this is there. Now, BRICS, another point of the BRICS was they established a new development bank. New development bank, the capital, share capital details, everything is there in the clipping. New development bank was established because the old institutions of IMF and World Bank, they have Western hegemony. They are completely under the Western control. Their share capital, their way of granting loans, everything is in the domain of, everything is dominated by the European Union countries, the countries of Europe and the US. But majority of development, majority of loans being borrowed are being borrowed by the global south, the developing countries. So if the World Bank and IMF are not willing to change their way of working, are not ready to accept this global economic shift that is happening from global north to global south, then it's time for, BRICS countries said, it's time for new economic institutions to replace World Bank and IMF to be created. and that is why the New Development Bank was created. So here is the factual part of the New Development Bank. Please read it. Fortaleza Declaration was the declaration. A summit happened in Brazil where it was decided that a new development bank, a new bank would be created, a new financial institution named as the New Development Bank would be created. Okay, it was in 2014, Fortaleza Declaration. At that time, BRICS summit happened in Brazil, city of Fortaleza. So you have to remember Fortaleza Declaration for New Development Bank in the light of the trigger factor that US President has talked about, taking a dig at, or he has talked about targeting the BRICS countries' goods emanating from the BRICS countries. This was all in today's news analysis, guys. We dealt with GS Mains Paper 1 oriented news clipping, social issues, the women protection, the section 375. We talked about this BRICS summit. We talked about green bonds, sovereign green bonds, environment and ecology to an extent. Then GS Mains Paper 3 economy, that news article of sovereign green bonds caters to. Then we talked about governor's role, center state relations. Article 176 was in news today. Then we talked about your Medical Termination of Pregnancy Act, GS Mains Paper 1 and GS Mains Paper 2. What was the difference between the old Act of Medical Termination Pregnancy Act 1971 and the new amended Act of 2021, right, which covers the unmarried women also, women who are victims of rape, then live-in relationships, etc., are also covered in the rubric of the new Act. This was all in today's news analysis. All your queries on the Telegram channel, Telegram group that you posted yesterday will be catered to across the day through my voice message, wherever relevant, wherever more applicable. I'll address them through the voice message or through the text, whatever is more suitable for addressing your query. And the PDF will be shared right away on the Telegram channel, the link of which is given in the description box. A small information about our All India Prelims mock test. Even if you are not appearing this year, okay, even if you are not appearing, do get to see the quality of our questions the PW Only IS is conducting. Spare one Sunday, okay, the test is going to happen on 23rd, so you can attend this test. This is the QR code. You can scan the QR code and enroll, register yourself for the All India mock test prelims. This way you are not just preparing for one day exam. That day will come after 365 days. I would suggest rather keep on appearing these type of tests, okay, to get your to acquaint yourself with the quality of questions, okay. Prelims, kind of the analytical questions, conceptual questions, you'll get the hang of the actual exam hall there. And not only this, whenever you come across some good quality examination conducted by UPSC or state PSC, don't get digressed, but appear in that also, so that the fear of that one day, one fateful day, will be very high if you just bet all your horses on, all your stakes on that one day. It will be good for your health, and your, the phobia will go down if you keep on appearing after every 2 to 3 years, 2 to 3 months, in an exam conducted by, one day exam conducted by RBI, UPSC, CDS exam. These one day exams, keep on appearing in them. Otherwise your fear on that day will be very high. You might fall prey to some, panic attack also. That day it happens, people get fever, etc., nausea, etc. To avoid that, regarding this, do appear in this test. It will really help you. I had gone through the quality of the questions that is being prepared, so it's strictly according to the UPSC pattern, guys. This was all in today's news analysis. I take your leave. Thank you. Bye bye. See you again tomorrow at around 8:15, guys. Thank you. Bye bye.